introductions, and I'm going to do this in a little bit more colloquial. I'll tell you the basics, which is he's a graduate of the National University of Singapore and has an LLM from Harvard University. He was a private practitioner in Singapore for many years, including for the most part of the latter part of his career with Raj and Tan. He then became Attorney General of Singapore, went briefly on the Court of Appeal, and is now the Chief Justice of Singapore. I can tell you that quite apart from that basic CV, Sundaresh really is one of the true visionaries of international dispute resolution. Many of you who practice in international arbitration will appreciate that Singapore has increasingly assumed a role, particularly in the Pacific Ring, but globally as one of the sites at which international arbitration goes forward, a neutral and independent site in which parties with no necessary connection to Singapore cite their arbitrations. Sundaresh came to the Singapore, as we speak here, or actually as of yesterday, there's an outfit called the International Council of Commercial Arbitration. Notwithstanding its name, it deals with a wide range of dispute resolution, including investor-state arbitration. For the first several days of this week, its biennial Congress was happening in Miami and gathered some 1,000 international arbitration practitioners. At the same time, we have close to 1,800 international lawyers here. Sundaresh, 2 years ago at the biannual Congress in Singapore, challenged the international arbitration community with a lecture at the outset of that Congress and really pointed out not only the achievements of international arbitrations, but the challenges, particularly of legitimacy, that the system faced. And it really was a challenging and provocative lecture, which he's followed up on, including yesterday at the closing plenary of the ICA Congress. And so having him come here and address us in the same vein will be a great treat. I should tell you that in his position as Chief Justice, Sundaresh has taken on really, the Chief Justice Menon has taken on really the same challenge and is thinking about Singapore and thinking about dispute resolution in this era of global trade, internationalization, and how Singapore might serve as a judicial site of dispute resolution. And has been thinking progressively, creatively, and we hope productively about how international disputes may be resolved as we go forward. I will tell you, too, that Sundaresh, as of 2 days ago in Miami, was flat on his back with a piercing fever and barely able to walk. He pulled himself out of bed to deliver the follow-up lecture at the closing plenary at ICA yesterday, and now is a little bit stronger. And so for a little while, there was a great fear, and nobody had the fear greater than me, that I was going to have to pretend to be Sundaresh Menon. And since I tell you, I could never be Sundaresh Menon, that was really more than a challenge. But Sundaresh is able to give the lecture, but it's a relatively long lecture, and I think we're going to relieve him of the burden of staying longer and answering questions. So we're going to have the lecture. We're enormously pleased to Charlie for making this possible, and Chief Justice Menon, to you for being with us.
Thanks very much. Thank you very much, Donald, and thank you, Judge Brower, for making this possible. And thank you, ladies and gentlemen, for taking the time to be here this afternoon to hear me speak to you about the transnational protection of private rights. In the wake of the 2 world wars that rocked the international order in the 20th century, the right of nations to self-determination was enshrined in Article 1 of the United Nations Charter. Among the most important developments of the post-war era has been the disintegration of the colonial empires and a consequent massive increase in the number of states and polities. With this came a proliferation of borders that each contained different sovereign legal systems and laws. At the same time, the rebuilding and reconstruction of the post-war world created both the impetus and the opportunity to focus on development and economic growth. So even as the number of discrete states and polities increased, the world witnessed a rapid increase in the connectedness of its economies and its cultures. Tom Friedman observed in his international bestseller, The World is Flat, what might now be accepted as conventional wisdom. That increased connectivity has resulted in the accelerated flattening of the world facilitating the phenomenon of globalization. But globalization occasions the need for a more homogeneous and harmonized legal framework that can accommodate the vast increase in economic relationships which cross those borders that might not previously have existed or been quite so firm. With the fragmentation of the colonial empires and the birth of scores of new states in the so-called Third World, developed and developing countries found themselves separated by massive gulfs in terms of their relative states of social, economic, and political development. In these circumstances, there were always going to be difficulties in attaining transnational harmonization in the law, policy, and practice pertaining to commercial transactions. At the dawn of a new millennium, we face the challenge of dealing on a global basis with movements in opposite directions. On the one hand, the emphasis on decolonization and self-determination in the post-war era has seen a movement towards building barriers and fixing legal and political boundaries between jurisdictions. On the other hand, globalization sees a movement to break economic barriers and transcend boundaries. While the first movement sees growth in the number of individual systems of law, the second calls for laws and legal systems that are not so tightly constrained by jurisdictional boundaries so that they can more effectively support the immense growth in transnational trade and commerce. My focus today is on the legal protection of private economic rights in the transnational arena. The term international economic law has been adopted as a shorthand reference for regulation in this immense field. I propose to approach my subject by considering the regulation of transnational economic relationships at three different levels. First, where a party's rights are not regulated or governed by any contract, but where there is nonetheless a need to protect one's interest or rights in commercial property. Second, where there is a contract between the parties which they look to protect their rights as between themselves. And third, where a foreign investor looks to protect its investment against unlawful interference by a host state. These are not exhaustive of the range of regulatory mechanisms that affect transnational economic relationships. For instance, even though international trade law or world trade law relates to international rules and conventions that seek to manage trade relations between states, yet these undoubtedly impact directly on individual actors. While this is certainly important in international commerce, I do not discuss it as a discrete category this afternoon given the constraints of time, and instead focus on the three levels which relate to private actors being directly involved in protecting their private economic rights. I begin with a brief overview of the existing legal order at each of the three levels, focusing my observations and analyses on selected fields of law or issues. I look to identify some of the challenges and thereafter to close with a section where I share some thoughts on what might lie ahead. Contracts are the lifeblood of commerce, yet there are many instances where there is a need to protect commercial property in the absence of any contractual arrangements. This can arise in many discrete areas of law, including, for instance, the wide range of economic torts such as conspiracy, trade libel, conversion, and so on. I focus today on the transnational protection of intellectual property rights. IP is essentially a jurisdiction-bound area of law, and the drawbacks that exist in this area are clearly exposed in an increasingly transnational marketplace. IP rights are traditionally territorial in nature. They are conferred by individual jurisdictions for rights owners to reap within that jurisdiction the economic benefits of their protected subject matter. They had their genesis in a world that was vastly different from ours today, and may be traced at the very least to legislation in the 17th and 18th centuries, when there was hardly any need for the protection of IP rights to be robust across national borders. IP was mainly exploited within a limited geography, and there was little scope for extraterritorial infringement of IP rights. In these circumstances, the territorial nature of the regime did not pose much difficulty. The incidence of cross-border IP interests has grown significantly in recent years. There are numerous actors, including the World Trade Organization, the World Intellectual Property Organization, as well as state governments, national judiciaries, and various regulatory boards. There are also many new sources of law, including free trade agreements and bilateral investment treaties. And the jurisprudence of national courts also contributes to the pot. With so many different actors and sources of law, the need for harmonization of the international IP framework has been the subject of discussion for some time. Developments in the technology patents industry provide a sign of our times. In the massive Apple-Samsung patent dispute, the late Steve Jobs memorably declared that he was willing to go to thermonuclear war, spending his last dying breath and every penny in Apple's vast reserves to right Android's wrongs. It sounds like an extract from a science fiction movie. Apple commenced patent litigation against Samsung in April 2011, and by July 2012, the thermonuclear war had reached the shores of the United States, South Korea, Japan, Germany, the United Kingdom, France, Italy, Netherlands, and Australia. At last count, the two technology giants were involved in more than 50 lawsuits globally over claims for damages that ran into the billions of dollars. We should not be surprised if more such disputes follow. In fact, a whole new patent licensing industry has already emerged, with technology companies reverse engineering new devices for the purpose of helping patent owners to prove that the devices of others infringe their patents. Not only do these massive international IP disputes involve huge amounts of money, they also have to be fought in a multitude of jurisdictions, with potentially different standards being applied and different outcomes being reached. While broad frameworks for the protection of IP rights are being harmonized to a growing extent, arising from efforts to comply with TRIPS obligations, there remains an essential lack of common standards. In part, this is because the application of the law by national courts has varied tremendously within those frameworks. How a particular state chooses to protect IP rights, which in essence are artificial monopolies, can depend heavily on its relative stage of economic development and indeed even on its moral or other values. As has been observed, while IP is largely a legal construct, it is not just about law and economics. It is often also about politics. In designing the international IP system, the balance sought is that between universal norms and the national autonomy necessary to legislate a substantive balance appropriate to each nation state. However, it is extremely difficult to attain meaningful international consensus on how that precise balance should be struck. This is unsurprising given that the national strategic interests of the various states will not be aligned. For instance, while the United States and the European Union have tried to encourage other countries to adopt higher IP enforcement standards through ACTA, the increasingly powerful developing countries such as China, India, and Brazil have shown no urgent desire to join such a system. A particular example draws from the experience in the pharmaceutical industry. States economically dependent on pharmaceutical companies tend towards applying IP laws to protect those interests, while states facing increasing healthcare costs tend towards laws which keep healthcare affordable. The recent decision by the Indian Supreme Court rejecting Novartis' attempt to seek the evergreening of a pharmaceutical patent illustrates the point. In researching this paper, I did come across an example of the successful harmonization of IP standards in the Andean region. It seems implausible that this can extend across a wide geography. Indeed, such harmonization was largely premised on factors that are far more likely to obtain in a regional rather than in an international context. The Andean states were in similar states of development and therefore had similar interests in relation to IP policy. They were thus able to agree to a common set of laws which were clear, detailed, and precise. They were also able to agree on common adjudicatory mechanisms. As a check on the system, private actors were also allowed to file complaints against a member state's alleged non-compliance. This confluence of factors, which accounts for the extensive degree of agreement that was reached, is unlikely to occur in the international context in the foreseeable future. Second, as illustrated by the Apple-Samsung dispute, the multiplicity of proceedings across different jurisdictions is largely unavoidable with major transnational IP disputes. This arises because where there has been an alleged infringement of IP rights in more than one jurisdiction, the doctrine of res judicata does not always or necessarily apply. Nor, as a matter of law, can there be cause of action estoppel. A French patent registration is a different juridical and legal creature from its English counterpart. A French judgment on the infringement of a French patent cannot give rise to cause of action estoppel between the same proprietor of the equivalent English rights and the same defendant who is performing equivalent acts in England. And that's because the basis of the cause of action is different in each case. The multiplicity of proceedings gives rise to at least three major problems. First, there is an immense strain on the resources of the parties. The cost of the Apple-Samsung wars is not known to the public, but one can be certain that the figures will be staggering. The same can safely be said about the pharmaceutical patent wars. While lawyers might not be complaining, one wonders if these vast amounts of money would not be better spent on innovation, research, and development. Second, the need to sustain or defend multiple proceedings potentially engenders injustice in view of economic inequalities between the disputing commercial parties. Deep-pocketed multinational corporations might well be able to simultaneously finance large-scale litigation across numerous jurisdictions. But smaller enterprises might not be able to afford the cost involved in protecting their own IP in this way. And third, national court systems are often called on to bear an immense cost to resolve such disputes. The Australian leg of the Apple-Samsung dispute was so large that it necessitated an unprecedented assignment of 2 federal court judges to hear that case at first instance. The matter commenced in 2011, and the hearings before these 2 judges have an estimated end date sometime this month, apparently. It might be anticipated that one or both parties would lodge an appeal, as has been done throughout the interlocutory stages of the matter. Will a jurisdiction less wealthy than Australia be able to devote such judicial resources to settle a battle between deep-pocketed MNCs? And in any case, should taxpayers be financing judicial systems that are deployed to resolve these wars? This is an important question because national courts generally do not recover the full cost of running their operations. All this must be seen in light of the fact that commercial realities may impose immense time pressure on the parties and the courts to resolve their multi-billion-dollar lawsuits within a relatively short time. So, it has been said that the ability to enforce IP rights on a transnational basis is crucial for their effective protection. But in fact, there remains a conspicuous lack of harmonization on the important issues of jurisdiction, applicable law, as well as the recognition and enforcement of judgments in the context of IP rights. In light of the modern reality that invention, innovation, and originality are increasingly realized on a far more international and collaborative basis, the lack of harmonization in the international IP regime and the jurisdiction-bound framework for the protection of IP rights stand as drawbacks or shortcomings in the supportive machinery for this aspect of transnational commerce. I move to the second level of the transnational protection of private rights, where the parties look to protect their position and their commercial interests through contracts. The rise in transnational contractual arrangements has inevitably spawned a corresponding increase in disputes between parties from different jurisdictions. And this has given rise, or gave rise, to calls for a dispute resolution system that had at least two primary characteristics. First, there had to be a neutral forum for the resolution of disputes so as to minimize the concern that disputes would be resolved in the unfamiliar judicial and legal terrain of a foreign land. Second, decisions had to be clothed with cross-border enforceability. The latter provided the impetus that led to the emergence of the 1958 Convention on the Recognition and Enforcement of Foreign Arbitral Awards, or the New York Convention. And with it, international arbitration became a viable system of international commercial dispute resolution. In contrast to perceptions concerning litigation in national courts, arbitration promises neutrality, international enforceability of awards, flexibility, and confidentiality. It also held the promise, at least initially, of a faster and less expensive form of dispute resolution, as well as the avoidance of some of the complexity and excessive legalism and formality of traditional judicial proceedings. Parties began to turn to international arbitral tribunals for relief, with national courts serving as supplemental aids to support these arbitral proceedings. By the turn of the millennium, arbitration had become a commonplace mode of dispute resolution provided for in an immense range of commercial arrangements. And by the end of the first decade of the new millennium, arbitration perhaps had become the preferred method of resolving international commercial disputes. There is empirical evidence to support this in the impressive statistics put out by the arbitral institutes. But even as the international commercial arbitration might be seen as the preferred mechanism for resolving cross-border transactional disputes, a targeted survey of corporate counsel published in 2013 by the School of International Arbitration at Queen Mary's in London bears noting. The report indicates that corporate counsels refer 47% of their international disputes to litigation, and this is the same proportion they refer to arbitration. Even allowing for the fact that arbitration might not be an option in some of those agreements because there might be an absence of arbitral agreements or because the subject matter might not be arbitrable, the statistic does seem surprising. Certainly in the course of the last couple of years, there has been a chorus, some might say a cacophony, of voices suggesting that this might be due to a number of issues that threaten the continuing vitality of international commercial arbitration. I briefly touch on four areas. Among the more frequently raised concerns is the contention that international commercial arbitration has lost its edge in avoiding the delays, contentiousness, and costliness of judicial trials. The flexibility and relative informality of arbitration was once its key advantage. Ironically, that flexibility might allow the practitioners of arbitration to create highly litigious and legalistic proceedings that increasingly simulate or even surpass litigation in terms of the amount of time required to complete the dispute resolution process, and with it, the amount it will ultimately cost. What is perhaps surprising is that the criticism leveled at arbitration on the grounds that it is characterized to an increasing degree by judicialization or legalization is not a wholly new development. A quarter century ago, in 1989, Lord Mustall observed that commercial arbitration was developing into a process with, and I quote, all the elephantine laboriousness of an action in court without the saving grace of the exacerbated judge's power to bang heads together to bang together the heads of recalcitrant parties. How did this come to pass? I think there are three reasons at least. First, the adversarial culture of Anglo-American legal practice has perhaps contributed to the transplantation of litigation strategies and methods into international commercial arbitration. Second, the increasing formality of arbitration today probably has much to do with the reality of the commercial world. Large commercial transactions featuring multiple parties and contracts have become far more common, and the disputed amounts are now regularly in the tens or hundreds of millions or even billions. With the stakes going up, winning has become all-important and all-consuming. Third, much delay and laboriousness might arise out of the absence of appellate mechanisms. The lack of an avenue for appeal is traditionally justified on the ground that finality is achieved more quickly. But as the practice of arbitration has evolved, the absence of appeals has encouraged parties to approach the process as a one-shot contest in which the winner takes it all, and so to pour extensive resources into the battle. One might question the efficiency of such a process as compared to the traditional mechanisms where issues are distilled as they progress through the appellate ladder with greater focus and precision at each rung. The absence of appeals has also diverted more attention towards the setting aside of arbitral awards. Setting aside is a limited opening that offers possible recourse for a disgruntled party. But the success of an application to set aside an award depends in large measure on the supervisory court's approach towards arbitration in general and how it interprets the circumstances of each case in particular. And arbitrators are generally keen to avoid even tenuous grounds for the setting aside of an award. And so to bulletproof the award, there is sometimes a tendency to be more liberal in admitting evidence, in allowing more extensive document production processes, and in granting extended hearing time. A second area of concern pertains to whether there is a need for a widely accepted set of ethical standards or guidelines in the context of international commercial arbitration. In the past, arbitration was a small industry that could be effectively governed by implied understandings amongst actors in the industry. But the internationalization of arbitration has resulted in an exponential increase in the number of arbitral institutions, cases, and practitioners. It is impossible for the industry to continue to depend on implied norms, understandings, peer standards, and shared values when these might no longer even exist. The absence of widely accepted standards must enhance the risk of predictability, the risk of unpredictability in terms of how this great diversity of practitioners are going to conduct themselves in their cases. A third area of concern is the ad hoc nature of national courts' oversight of arbitration, the inherent consequence of which is that from time to time there will be inconsistent and even conflicting results in enforcement. The Dala cases provide a good illustration of this point, where the English and the French apex courts were separately called upon to decide the issue of whether the government of Pakistan was bound by the arbitration agreement, notwithstanding that it was not in terms a party to the contract. On identical legal issues and identical facts, the apex courts in these two countries came to diametrically opposed conclusions on the enforceability of the award. As we in the Singapore Court of Appeal recently observed, while the New York Convention sets out a common framework with a common set of grounds for the enforceability of awards, the enforceability of a particular award ultimately depends on the interpretation that is placed on those grounds by the national courts. I mentioned a final area of concern, namely the lack of consistency and predictability that might sometimes stem from a lack of publicly available jurisprudence. It is true that there is a growing body of lex arbitralis materialis containing transnational substantive rules which arbitrators can draw upon or refer to in deciding disputes. International commercial arbitral tribunals increasingly refer to and rely on other awards as precedents in their decision-making processes. But the coherence of jurisprudence emanating from tribunals remains challenged by the confidentiality of arbitral proceedings, as well as the absence of appeal and error correction mechanisms. As an increasing number of major and complex commercial cases are heard by arbitral tribunals rather than by municipal appellate courts, this threatens to hinder the development of a coherent, freestanding body of substantive international commercial law, and over time, this must add to the cost of transnational trade. The system of international commercial arbitration has undoubtedly been a boon for international commerce in many ways, and it is rightly to be very warmly applauded. But for present purposes, I suggest that it does not hold a complete solution. And as the field expands with an ever-increasing number of practitioners from an ever-broadening diversity of regions, we can expect some of these difficulties to become more pronounced. I turn to the third level at which private rights are protected in the transnational system. This is where states bind themselves by treaties to act appropriately in relation to the private investments of foreign nationals. This is done on terms that the investor is entitled in his own right to take action by way of arbitration against the offending state. Following decolonization in the post-war period, numerous multilateral approaches were taken to develop the substance of international economic law systematically and in a more universally agreeable manner. In keeping with the post-war abhorrence of war and the use of force, states moved away from gunboat diplomacy in economic relations, seeking instead multilateral international agreements for the protection of the private rights of their nationals. However, as has been the case with the international IP regime, multilateral solutions remained elusive because the interests of developed and developing countries were divergent. Developed countries then devised bilateral solutions in the form of BITs to protect the investments of their nationals from uncompensated expropriation by host developing countries. In just over half a century, investor-state arbitration has evolved into a robust system of transnational adjudication, dealing with disputes that arise out of a web of more than 3,000 BITs, regional free trade agreements, and multilateral agreements. It involves a unique mix of international law, international commercial arbitration, and private and public law. The upshot of the system is that private investors no longer have to rely on diplomatic protection. Under BITs, investors can directly challenge state actions that negatively affect their investments. Judge Charles Brower argues in a draft article which I've had the benefit of reading that investor-state treaties limit political discretion, avoid internal political methods for resolving disputes, and therefore work to promote the rule of law. In this way, these treaties and the tribunals called upon to apply them play hugely important roles in shaping an evolving body of international law. Just a month ago, the United States Supreme Court rendered its judgment in BG Group against the Republic of Argentina. The key issue in that case was whether it was the courts or the arbitrators who should decide certain threshold questions. While this was reportedly the first matter pertaining to investor-state arbitration brought before the US Supreme Court, the United States is no stranger to investor-state arbitration. Indeed, one of the first impressions I had of the power of investor-state arbitration was formed here in the United States during the early years of this century. I had just become a partner of a major law firm here, and my introduction as an arbitration lawyer was almost inevitably a prelude to a conversation about the case of Lowen Group against the United States. Lowen was the first arbitration under the investment chapter of the North American Free Trade Agreement that was based on allegations that an American trial had been conducted in a manner that amounted to a denial of justice under NAFTA and international law. But it is by no means an isolated case in the international scheme of things. In the 2009 case of Saipem against Bangladesh, an ICSID tribunal held that certain orders of a Bangladesh court amounted to expropriation because the orders effectively took away the fruits of an arbitration award made in favor of the investor. More recently, the 2011 case of White Industries against India, an Australian company brought an investment treaty claim against India on the grounds that it was unable to enforce an ICC award that had been rendered about a decade earlier. The tribunal held that pursuant to the MFN clause in the India-Australia BIT, the company could take advantage of the effective means of enforcement obligation found in a subsequent BIT that India had entered into with Kuwait. The tribunal therefore held India liable for failing to provide an effective means of enforcing the ICC award. And that failure essentially constituted in the fact that India had an ineffective in some respects, inefficient legal judicial system. The fact that actions of national governments or courts might result in an international wrong by the state is not an entirely new or fresh development in international law. However, the Lowen, Saipem, and White Industries cases illustrate an important change in the actors who are now empowered to dispute and decide issues of state accountability and the circumstances in which they may do so. These tribunals, on the one hand, have taken pains to explain that they do not sit as final super courts of appeal. On the other hand, they have shown a readiness to review decisions of national courts. This raises some quite important questions. Is there now an emerging recognition that states might be held accountable by investor-state arbitral tribunals for the decisions of their courts, or, as in the White Industries case, for the efficacy of their judicial systems as a whole? How will a line be drawn between a judicial determination that gives rise to a treaty claim on the ground that it was wrong enough to constitute an illegal interference with the claimant's property rights and one which does not? The investor-state arbitration regime was based on the international commercial arbitration model. It is questionable whether this is appropriate for adjudicating disputes involving sovereign states and public interests. I make just 3 brief points. First, the composition of investor-state arbitral tribunals has come under great scrutiny. The regime features a select few individuals to review and evaluate state actions, even though they are largely unaccountable to the constituencies that their decisions affect. While these arbitrators are widely respected and experienced in commercial and other areas of law, and might in fact have experience working in and advising governments and international institutions, they might not necessarily be attuned to the domestic public interests and policy concerns of the sovereign states in the cases before them. There is also a perceived lack of representation amongst arbitrators from developing countries, including from Asia. One study notes that even where there is Asian representation in ICSID tribunals, this generally consists of a small group of repeat players. Second, there are concerns with issue conflicts. Issue conflicts may arise in various ways, perhaps most notably where the arbitrator concurrently acts as counsel in another case pertaining to similar issues, so that a decision made as arbitrator may impact the case in which the arbitrator is concerned as counsel. Issue conflicts are potentially serious in the investor-state arbitration context because these often concern the interpretation of BITs that contain similar provisions and give rise to similar legal issues. Third, concerns have been raised with regard to the lack of public participation in investor-state arbitration. The confidentiality of investor-state arbitration proceedings flowed from its roots in international commercial arbitration. However, in view of the public interest in investor-state arbitration, there has been a push for increased transparency. This has been reflected to some degree in the amendments to the ICSID arbitration rules and the introduction of transparency-enhanced procedures in new investment treaties such as the US-Singapore FTA, as well as the recently announced CETA or Canadian-EU FTA. But there is another set of concerns that relate to the substantive law. Investment treaties started as lex specialis instruments that emerged in a time of ideological divergence between the developed and developing world. Such treaties were skeletal because of a conscious desire not to hamstring the development of a system for investor-state dispute settlement by arguing over the contentious issue of what the substantive law should look like. But the consequences of having a system that rests on bare bones provisions that are left to be fleshed out by individuals appointed to hear disputes when they arise are that first, many disputes can and will arise because they're not obviously excluded given the open-ended way in which the obligations have been framed. And second, a great deal of law is going to be made by those entrusted to decide these cases as and when they arise. This also means that some of the traditional concepts that underlay investment treaties might be stretched beyond what the parties to the treaties themselves might have contemplated them to mean. For instance, the concept of expropriation was historically concerned with the physical seizure or transfer of tangible property or the nationalization of foreign-owned assets. It has in fact been extended to a broad range of economic assets, including contractual rights. Another example relates to MFN clauses. Such clauses were originally intended to ensure that host states would not discriminate in terms of the competitive opportunities offered to treaty partners. But tribunals have interpreted MFN clauses broadly, seemingly allowing investors to be able to pick and choose from the provisions present in BITs between the host state and the third-party state. This can sometimes enable an investor to construct a cause of action that might not have been in the contemplation of the contracting states. The obligations of the contracting states might therefore come to be defined by a patchwork of the most favorable provisions contained in a raft of treaties linked by MFN clauses, potentially undermining the sometimes calibrated result of interstate negotiations. Moreover, there is no single body that has the capacity or competence to rationalize, to reconcile, or to moderate the emerging jurisprudence of these ad hoc tribunals. There is no avenue of appeal to help strip away some of the errors, incoherence, or inconsistencies in the arbitral jurisprudence. One writer has suggested that the international arbitration framework may be inherently unsuited to handling issues involving sovereign and public interests, and that perhaps these matters should be carved out as being unarbitrable. I'm not sure that I fully agree with this view. But what does emerge from recent developments is that some states have attempted to recapture the authority to interpret their treaties. Under the Singapore-United States FTA, a joint committee of government officials may issue binding declarations, binding interpretations of the agreement. The Malaysia-New Zealand FTA and the ASEAN-Australia-New Zealand FTA also incorporate express provisions for tribunals to request joint decisions from the parties declaring their interpretation of disputed provisions. And under the CETA, the EU and Canada may issue binding interpretations on what they originally meant in the agreement and to participate in arbitrations in relation to questions of interpretation. The constraints of time permit only the briefest survey of the proverbial tip of the iceberg that is international economic law today. Our traditional systems for the resolution of disputes featured a design with a jurisdictional focus, but these strain to cope with a world in which there are extensive transnational economic relationships. Arbitration evolved to provide a part of the answer. The success of arbitration has rested to a large extent on the fact that it enjoys a transnational character by virtue of being underpinned by the New York Convention in the case of commercial arbitration, and in the case of treaty arbitration, also by the relevant bilateral or multilateral investment treaty. This has seen the role of the courts in this enterprise somewhat sidelined. There are exceptions. The most notable is perhaps the Commercial Court of England and Wales, which has seen a considerable increase in its caseload involving either one or all foreign parties? Is it possible to reimagine our paradigm? To begin, are there any themes that emerge from the discussion thus far? I suggest that at a broad level, there are perhaps 5. To cope with the transnational trading environment of today, it might be timely to recognize that courts have a potentially significant role to play in the resolution of commercial disputes alongside arbitration. This could be significantly enhanced and aided if there was a framework to avoid the need to relitigate the same issue across many different jurisdictions. Second, to the extent possible, it would be highly desirable to have consistency in outcomes when the same sort of issue has to be resolved by different tribunals. This might arise in the context of a single award being enforced in 2 different jurisdictions, as was the case in Dala, or in the context of a similar substantive question being tried by 2 different tribunals. Third, it would be desirable in a world where our economic activities transcend borders with ever greater frequency to strive for convergence in substantive commercial law, to the extent this was possible. This is an important part of assuring consistency in outcomes, and if it was achieved or achievable, it would reduce transactional costs as well. Fourth, arbitration is likely to remain the predominant method for the resolution of transnational commercial disputes. But amidst the considerable growth in the diversity of practitioners, in the range of debates and issues, and in the sheer incidence of disputes, there might perhaps be a need to refresh our outlook and approach to a number of matters, including the way we conduct arbitrations and whether we should be developing more consistent approaches to such things as ethics. And 5, investor-state arbitration, despite some signs of a backlash, remains the best available method for the protection of private investments from the acts of a foreign host state. But the emerging question is how the interests and the intentions of the states that negotiated those treaties might be accorded sufficient consideration. If for a moment we could embark on a thought experiment, putting aside the limitations of our current thinking and our beliefs about the international order, how would we envisage responses to these challenges and themes? In a lecture I delivered at Lincoln's Inn in London late last year, I suggested that the harmonization of commercial law and of commercial dispute resolution processes is a good we should work towards because it will reduce the transactional costs of cross-border businesses. The uncertainty engendered by the need to translate legal relationships across the boundaries of different legal systems reduces investment, consumption, and economic performance. In the same lecture, I suggested that we might approach the harmonization by way of a 3-act script. I developed these themes by proposing ideas that might move us towards an improved and perhaps fuller model for the transnational protection of private rights. In essence, I suggest that we should strive towards recognizing that courts might play an enhanced role in the resolution of transnational commercial disputes alongside arbitration, that this would assist in the development of convergence in substantial commercial law, and alongside this, the arbitration community should continue to re-examine and refresh its practices. So the first act concerns the harmonization of laws on the recognition and enforcement of judgments. This has been achieved to a considerable extent in the context of international arbitration pursuant to the New York Convention and the model law. But there is room to consider the same in the context of court-based dispute resolution mechanisms. The Hague Convention on Choice of Court Agreements, which aims to do for court judgments what the New York Convention has done for arbitral awards, is an interesting development. It will be applicable in business-to-business contracts that contain choice of court clauses. Thus far, the European Union, the United States, and Mexico are signatories to the convention, though only Mexico has ratified it as yet. The convention will enter into force with the ratification of just one more state. It is exciting to note that the European Commission proposed on 30th January 2014 that the EU approve the convention. When it is enforced, the Convention could prove to be a game changer in the international dispute resolution framework. It is a multilateral treaty that aims to increase the efficacy of choice of court agreements in transnational disputes and has the potential of widening the effect and enforcement of court judgments in contracting states. It will establish uniform rules on jurisdiction and on recognition and enforcement of foreign judgments in civil or commercial matters, and it will provide greater certainty for parties in transnational commercial contracts. It therefore holds the promise of a significant step towards the improved harmonization of international commercial law. Because the Convention would apply to judgments of courts that are selected by the parties in a way that mimics the emergence of favored seats of arbitration, this might likely see the emergence of a network of commercial courts which have wide international acceptance for competence, integrity, and commercial sensibility, functioning alongside the existing framework for international commercial arbitration. The success of the English Commercial Court, alongside London's dominance as a center for arbitration, suggests that litigation and arbitration are not necessarily competing in a zero-sum game. Rather, there is room for a wide range of options for the successful resolution of these commercial disputes. The impressive growth in the volume of international cases in the Commercial Court in London also suggests that parties are not necessarily as nationalistic as they once might have been about which courts can resolve their disputes, as long as there is an assurance of competence, integrity, and trustworthiness. I do not suggest this will be a panacea that avoids all the problems. The field of IP rights that I started with is a difficult one because IP rights are legal constructs and will ultimately be significantly shaped by idiosyncratic policies. But one could imagine the benefits to be had in the transnational protection of private rights if there was a framework for the effective enforcement of the decisions of a respected and competent court across borders. The second act concerns the improvement as well as the convergence of dispute resolution processes. Arbitration is presently the primary dispenser of justice in international legal disputes. It plays a hugely important role in regulating commercial as well as investor-state relationships. International arbitral think tanks and institutions, and in the context of investor-state arbitration, states themselves might work together better in developing responses to the issues faced. Last year, we convened the 2030 edition of the Singapore International Arbitration Forum. It was entitled Adventures with Blank Sheets of Paper, a day of blue sky experimental thinking. It brought together an excellent cast of practitioners, academics, and judges. There was surprisingly wide consensus that there were significant areas for improvement. For instance, many speakers thought that there was a need for arbitration to move away from simulating litigation. It was also thought that arbitrators should be encouraged to be involved in cases from an early stage and to conduct active case management throughout the lifetime of the case. They should work towards tailoring ideal solutions or encouraging amicable settlements, and have greater regard to the Pareto principle, impose limits on hearing time, page limits, the scope of limiting the document production, and make necessary cost orders against recalcitrant parties. These are valuable and sensible ideas, but are we content to seed them as ideas and wait to see if they will take root? The difficulty with this is that the arbitration industry is dominated by insiders who tend on the whole to be reasonably comfortable with the status quo. Why fix something if it ain't broke yet? Moreover, the most important and influential voices often belong to some of the busiest practitioners. As a result, it might be asking a lot to expect that reforms or refreshed practices will naturally and spontaneously occur. Much of the international arbitral caseload is administered by a relatively small number of arbitral institutions, which are aided by the presence on their boards of some of the leading arbitrators in the world. Is it beyond hope that they might design ethical codes and regulations that might one day be internationally harmonized, that they might add teeth to those codes by specifying sanctions and establishing formal processes for managing ethical misconduct of counsel or of arbitrators, that they might establish accreditation procedures and create arbitrator databases, that they might simulate the use of the best practices in how we conduct arbitration. The theme of the just concluded ICA Congress that Donald spoke about was legitimacy, myths, realities, and challenges. It was a fantastic Congress that featured a painstaking process of reviewing current practices in arbitration from a variety of perspectives to ascertain whether the concerns expressed over arbitration are myths or realities. Allowing for the fact that there might be some divergence of views on each of the angles examined, the presence of prominent and respected practitioners on each side of the debate suggests the safe conclusion that there are some myths, some realities, and an awful lot of challenges. This is not to attack arbitration, but it is to provide the impetus for arbitration to raise its game. Separately, the idea of introducing appellate mechanisms in international arbitration as a means for error correction and precedent creation has been floated before. If it were possible to construct an acceptable mechanism, it could go some way towards bringing legitimacy and coherence to the disparate web of arbitral decisions in the interpretation of treaties. It may be thought unlikely that states would agree on a true appellate structure to unify the system of disparate investment treaty decisions. After all, a proposal for an appellate mechanism was tabled by the Secretariat of the ICSID a decade ago, and it hasn't gained traction. Although the appellate body of the WTO shows that it is possible to have an effective and coherent system of appeals to resolve international disputes, the success of that system owes much to the particular supranational character of the WTO and the fact that it deals with interstate disputes. However, in recent years, it has become evident that even decisions and practices of apex national courts might be subject to the review of investor state tribunals. Perhaps because of this, more consideration is being given to the stipulation of rights of appeal with regard to investment disputes. For example, the U.S. Bipartisan Trade Promotion Authority Act identifies as a negotiating objective the provision for an appellate mechanism to provide coherence to the interpretations of investment provisions in trade agreements. A similar requirement for states to consider whether to establish a bilateral appellate or review body was included in the U.S. FTAs with Chile, Singapore, and Morocco, as well as in the 2004 U.S. Model BIT. Similar provisions have been included in other treaties. Until and unless a meaningful system of appeals emerges, I envisage that states will look to play a greater part in the interpretation of investment treaties by ensuring some controls over the qualifications or even the identity of prospective arbitrators, and by creating the right to address tribunals on the interpretation of treaties, or even by retaining the right to issue bilateral statements of interpretation. If the courts are to play an enhanced role alongside international arbitration in the resolution of transnational disputes, I suggest there are two ways in which this might be done. Neither of these would require a fundamental overhaul of existing court procedures or practices. The first relates to the creation of specialist courts, while the second relates to developing cross-border connections between national courts. Specialist courts geared to deal with transnational commercial disputes could supplement the work done by the international arbitration system. These could be custom-built to run parallel with the domestic litigation framework and provide commercial parties with recourse to a specialist court with a full range of a court's coercive powers. A well-equipped specialist court with access to the infrastructure of cutting-edge case management systems and supplemented by the use of flexible procedures could expedite the dispute resolution process. Each case could be docketed, judicially managed, and decided by specialists in the relevant areas of law. It is not at all unlikely that such specialist courts could provide swifter and less expensive access to justice than arbitration, and the competition could ultimately work to the benefit of the users. While there might be some loss of party autonomy in the selection of panels and even of procedures, this should be balanced against the advantages that a good commercial court would bring. I should make a brief reference here to our plans to establish an international commercial court. In 2013, a committee comprising international and local jurists was formed to study the possibility of establishing such a court in Singapore. The report of the committee was made available on the internet as part of the public consultation exercise, which ended in January this year. While there remain several moving parts in this very substantial project, the Singapore International Commercial Court promises to offer an additional court-based dispute resolution mechanism for parties to resolve international commercial disputes before a group of eminent commercial judges drawn from our existing bench as well as from abroad. It is envisaged that the court will deal with categories of cases where the parties consent to use the court or where cases are transferred from the Singapore High Court. Within these categories of cases, the court may join third parties to the proceedings with or without the third party's consent. Matters will be heard at first instance by a single judge, although on the application of a party, 3 judges may be designated to hear a case. To avoid any possible issues associated with party appointments, the adjudicatory panels will be institutionally assigned from a panel of eminent jurists. To address issues of transparency and confidentiality, proceedings will, as a general rule, take place in open court, subject to certain exceptions. Transparency might well be attractive to the parties in some cases, and this would also facilitate the development of a body of jurisprudence. For international cases, there will also be wide rights of audience given to international counsel. The second court-based mechanism relates to developing deeper cross-border connections between national courts. National courts, and in particular commercial courts, would benefit from being less insular in their outlook and more open to discussions and debates with courts in other jurisdictions. A collaborative and consultative approach has proven to be useful even in an area of law as territorially bound as IP. At the 4th Global Forum on Intellectual Property that was held in Singapore last year, Chief Judge Randall Rader of the United States Court of Appeals for the Federal Circuit spoke of an IP case in which identical results had been reached on a patent dispute that was going on in the US, in the UK, and in Germany. And this was achieved because the national judges had discussed and explored how they might reach a common result subject to the limitations of their national laws. This has also been the experience in the context of cross-border insolvency matters. In a 1994 insolvency matter taking place in both the US and the UK, the judges of each court, sensing that they were each being given inaccurate reports of what was going on in the other jurisdiction, established an informal protocol to appoint a respected international practitioner to report to both courts. The success of that experiment prompted the insolvency section of the IBA to develop a set of principles which were thought to be of universal application in different regimes. In the field of international family law, regular communications on practices and even on cases might take place through an established judicial network. Cross-border intercurial collaboration may also ensure that foreign law will be applied in a consistent manner. In 2009, the Singapore Court of Appeal referred a question of English law arising in a case before the court to the English High Court. The English High Court gave its decision on the question, and this was subsequently admitted into the evidence in Singapore. Inspired by this, the Supreme Courts of Singapore and New South Wales, and subsequently the Supreme Courts of New South Wales and New York, have signed memoranda of understanding on references on questions of law to institutionalize such referrals. Had such arrangements been in place between the French and English courts, the inconsistent outcomes in Dala might have been avoided. There is also much to be said for regular knowledge sharing among commercial courts. Commercial judges from the courts of Hong Kong, Sydney, Singapore have for a number of years met periodically to discuss issues, share experiences, and learn lessons on the important issues in commercial law. Last year, we invited the High Court of Mumbai to join us, and more recently, we've invited the People's Court of Shanghai to join this dialogue. This leads me to the third act, the convergence of substantive law. An improved and harmonized dispute resolution process may form the foundation for deeper convergence of substantive commercial law. The international community has long recognized the need for uniform standards in international trade, and this has been manifested in what might loosely be termed soft law instruments. One example in the context of commercial sales is the Incoterms project. Incoterms, short for international commercial terms, are internationally recognized standards that are used in international and domestic contracts for the sale of goods. Another example in the context of the construction industry is the FIDIC forms. FIDIC publishes international standard form contracts for construction and engineering work, together with related materials such as standard pre-qualification forms and business practice documents. The work of such organizations significantly facilitates the international convergence of commercial law. We might envisage a greater emphasis on and efforts directed towards the development of more such norms and principles that serve the international commercial community. Aside from this, strengthening the community of commercial courts might point us more directly towards a deeper harmonization of substantive commercial law. These courts, though national for the foreseeable future, would feature judges who are focused on the resolution of transnational commercial disputes and would be well suited to developing a converging jurisprudence of transnational commercial law. The world today has changed dramatically in a remarkably short space of time. The proliferation of cross-border trade and investment flows has challenged the paradigm of operating in jurisdictional silos. The commercial world is moving at a rapid pace and threatens to leave our legal frameworks in its wake. I've floated some possible ideas to respond to the challenges we face. These will not materialize overnight or succeed as atomistic national projects. International collaboration, support, and paradigm shifts will be required. I've mentioned our plans to establish an international commercial court in Singapore. While it is still early days, we're hopeful that this novel mechanism, which we're designing and investing our resources in, will make a positive contribution to the global infrastructure for the resolution of these disputes. It is at least a statement of our intent to do the best we can in our shared endeavor to enhance the transnational protection of private rights in this new century. Thank you.
The promotion across borders of tribunals with competence, integrity, and trustworthiness, and the avoidance of jurisdictional silos. Chief Justice Menon, you've reminded those of us involved in dispute resolution of our potential contribution and the great challenge. The potential contribution, of course, is that the provision of truly competent tribunals with integrity and trustworthiness, the fair and efficient resolution of cross-border disputes, contribute to productive economic activity and hence to human welfare. And that's the potential contribution we can make. And at the same time, the challenge, of course, is to promote, and you've had a very useful emphasis on both arbitration and litigation. If we are going to share our futures, having courts in various jurisdictions who can both collaborate and provide that trustworthy service is a goal that all of us involved, a challenge to all of us involved in dispute resolution. So for your very deep thinking and your visionary approach, and for your willingness to come and address us here, we are deeply grateful. Thank you very much. And thank you all.